Hi friends, a new client comes to a lawyer and inquires about the fees. What are the fees you are charging? And the lawyer says, well, it's $100 for 3 questions. Oh, says the new client, isn't that a bit steep? And the lawyer responds, yes, what is your 3rd question? So I want to go about the appeal proceedings quite lightly in this video. You know already the formal proceedings from the opposition video. So there is something about the payment, about the formality check, the admissibility, then the grounds, then the reply to the grounds, the replique and the duplique. There is the absolute deadlines with a notice of appeal and the filing of the grounds, and there are relative deadlines with regard to reply, the replique and the duplique. So it's more or less the same. I will not go into much details here. What I want to refer to is the boards. So we have different boards within EU IPO, boards of appeal, right? 5 boards of appeal at this moment. It can be more if we have more appeals. It would be less if the appeal figures would drop, right? So each board has 3 to 5 members. It depends on the workload. And these are independent. The members are independent from the office, though they do not need to they do not receive directions from the president of the office or from the executive director of the office. They decide independently on the case law, on the basis of the case law and on the basis of the law, so to say, the trademark regulation or the implementing regulation. I didn't tell you so far. There's the trademark regulation and there's the implementing regulation, which goes a bit more into the details. Now you would ask, is there a difference to go to one board or to the other board, or is better to go to one board as an opponent and better to the defendant to go to another board? Well, these are now some 20 years of functioning of the different boards. The boards take some 2,000 actually, so some 2,700 decisions a year. That was not the case during 20 years, but they have now, I don't know, 5,000, 10,000 probably, 10,000 decisions have been taken, surely by the board. And the General Court, they take some 200 something rulings a year for quite some time now. So there are, I don't know, 5,000 surely, 5,000 decisions from the General Court and the Court of Justice. So my point here is the the legal questions are quite settled in the meantime, and it is makes no real difference if you come to one board or to another board. So the boards are not specialized in one thing and the other. There may be language-wise, there is one board which takes up more cases in German and others, they take much more cases in English. That could be one qualifying criteria. And one board is more for designs and the other board does not take design cases. That might be another. But on the substance, on what could be a prejudice or a good thing or a bad thing, I think this will not being influencing the case. So for you, it is the same if you go to one board or the other. A second issue, second aspect I want to get into are the hearings. In the last video, you heard that the office, the boards of appeal, they held a hearing with regard to bad faith. And I thought that was pertinent because the bad faith issue is about intentions, and intentions are difficult to put into facts, evidence and arguments, etc. So there is a personal aspect there, and that personal aspect could be revealed through the hearings, and it was in fact revealed through the hearings as the outcome tells you. Now, what I have seen a lot is that the clients, they want hearings. But for what reason do they want hearings? Hearings would be something if you cannot express it in writing, right? That must be in person, so to say. So if that is the case, then a hearing would be justified. But in many of the cases, and nearly all of the cases, 99% of the cases, everything could be presented in writing. So why do they want the hearing? Well, it could be, I'm not sure about it, I'm not anti-lawyer. It should be that the lawyer was used to these proceedings in court. This is not a court proceeding in strictly sensu, this is an administrative proceeding in the boards of appeal, but still it is organized like litigation a bit with, with the formal proceedings, with regard to the formal proceedings. So they like to come to Alicante in order to have a look around, I don't know, to have its clients brought in, to have justified more fees for the client. Well, it is not actually clear for what reason they insisted in that. Or perhaps the client was insisting, well, I want to look from the inside, or I want to look at the persons who will decide about my case. Maybe it was that the origin of the request. In any case, my point here is a hearing is an expensive instrument, and expensive instrument for the parties and for the IP layer of in general. So it is an expensive one. So think of the translator. So the translation is being done by a translator, which have to come from Barcelona over, and 1,000 euros a day, and so is charged by him. So that is not something which could be taken lightly. And the administrative work in order to organize that hearing is also something which burdens on the EU IPO, which at the end is being suffered by all the IP participants around the world. So that is one aspect. Another aspect is the lawyer briefs. I have seen a lot of briefs of lawyers. I participated in some 800 decisions over time. So I have seen a lot of lawyer briefs, and I must say there's a difference between lawyers coming from northern European countries and lawyers coming from southern European countries like Italy, Spain, France, Portugal, etc. So the northern tradition, so to say, legal tradition, it comes from legal tradition, right? That is not individual to each lawyer, but the country of origin and the judicial system of each country are organized in a different fashion. So the southern European tradition is more formal, it is more bombastic, it is more voluminous, it is more to make long briefs and long text blocks and citing all kind of case law. Whereas the northern European tradition, so the common law, Germany, Scandinavia, this is more to the point. I would say they would also cite some case law, but they are more to the point, to contribute to understanding what should be the resolution in the proper case. Now, what does a long brief means? So long brief, that could be 10 pages, that could be some annexes, case law perhaps, or others. Long briefs, meaning that they have to elaborate long briefs, right? It is more important work for them. They have to look for more text blocks or more things. The briefs have to be read by the other party, right? Just in case there was something which is important and which has to be addressed. And they have to read by the examiner, right? So the examiner has to look for what is important now in that brief and what is not important, and where do I have to look for a certain argument which I have to extract and reformulate in order to make it into the decision. And well, it could be also that the examiner comes from a South European country and wants a kind of voluminous decision and makes, repeating everything in every detail from the briefs in order to make the decision, well, in his view, more coherent or more complete or whatever it is. So my point here is everything contributes to a cost element. Everything is, it is something that it comes to something as an own industry. So the basic layer of business should be the basic layer should be the business, right? Or the IP business would support the business. So the basic layer is IP, that is a better way to express it, and on top there is the business. Why is it necessary that the IP is inflated with regard to the cost? So it should be up to the point cost efficient. It should be cost efficient because the more the IP invoice, the IP industry is being bigger, the more cost is inflicted on the business they have to support. So if they want to have their own life, their own existence, reasons of existence, they want to build an own rationale, I think they'll lose what is their original part to support the business and to make business, possible, so to say. Well, there is a school of Austrian economics, which I favor a lot. And there are some scholars which are saying, well, IP is something which not benefits society. And there's an idea which I think is important here to retain. Does IP benefit to society? I would say up to a point, yes, up to a point. Now, if the IP industry, if it is now called industry, if the IP industry would be too expensive and inefficient in a sense that it doesn't bring you further, it doesn't bring any added value to the business, to the party. So there would be, for example, one thing if one specific question is not being, so to say, decided by the general court, well, let's bring it to the general court, and then every other case which has the same circumstances will benefit from it because it has been clarified. So the appeals, for example, I was in a lot of appeals, and in the board where I was, the appeals were discussed, right? So 90%, it sprang into my eye, 90% of the cases were clear from the beginning, so there was no discussion point. It was crystal clear that the case has to be cited in that direction or in that direction. So why in the first place the appeal has been filed? So that is the question which springs to mind. And what is the benefit of society if the lawyer appeals against that decision, which will not have any success in the future? It inflates the cost of IP. So this is a general theme I have in my mind since long time. So we have to, you as a lawyer, I think, have responsibility to look at the benefit for society and to serve your client at the highest level. So these are the things which should be your standard. And with that, you would defend IP at the end. With the other approach of inflating everything, what you would do is destroy IP at the end, because it will say, well, it is too expensive. It does not give us sufficiently in return with regard of what are the costs of it. So I'm come back to the joke in the beginning. So the lawyer, which says, well, there are 3 questions, and none of the questions have something to do with legal terms, but still there would be charged the client. So it should not be like this, right?